Meeting, the second day. As you know, we were in closed session this morning, so we are now back in open session. And the first agenda item we're going to cover is item number 14, which will be public comment for items not on the agenda. The board may not discuss or take action on any matter raised during public comment, but we can. I can't hear you. Oh, I'm sorry, you're right. Quorum and roll call. Thank you so much. That's why you were whispering, so I didn't look like a fool. Yeah, I know. So often it doesn't work. It's the second day. I'm tired now. Please.
Akoy-Badu. Bernal.
She'll be joining us later.
Kasuga. Here. Erickson.
Here.
Fu.
Here.
Horn.
Here.
Jones. Phillips.
Here.
All right, you have a quorum.
Thank you very much. I even have it written here in big block letters with a highlighted. So number 14, public comment for items not on the agenda. Board members can't respond to those items other than to make a decision to add it to future agendas. Any public comments for items not on the agenda? And if you can, we've got an incredibly busy day, so if you could limit your comment to 5 minutes, that'd be great.
Yep. Good morning, Mr. President, members of the board. My name is Kathleen Russell. I'm the Executive Director of the Center for Judicial Excellence. Wanted to start off by thanking the board for convening what I thought was a very fruitful first step in dealing with some of the child custody issues that are plaguing California and involve a number of the board's licensees. We had a really productive meeting. I know it's on your agenda, so I'm not going to belabor that now, but just want to state that we do hope that something fruitful and tangible and meaningful will come from what was a productive meeting. And we really appreciate this board taking the time and putting the resources into making that happen. I did just want to update the board because it does relate to your licensees that 4 days after the stakeholder meeting in Sacramento, we worked to get the U.S. House of Representatives to pass a child safety resolution. And I just wanted to briefly touch on some of the summary of the resolution so that you can see why it is relevant. This was passed on a voice vote with no opposition, that it expresses the will of the Congress that child safety is the first priority of custody and parenting adjudications, and courts should resolve safety risks and claims of family violence before assessing other best interest factors. It also states that all evidence admitted in custody and parenting adjudications should be subject to evidentiary admissibility standards, which is a big problem in the courts. Here's the relevant part for you. Evidence from court-affiliated or appointed fee-paid professionals regarding adult or child abuse allegations in custody cases should be considered only when the professional possesses documented expertise and experience in the relevant types of abuse, trauma, and the behaviors of victims and perpetrators. It also states that the states should define required standards of expertise and experience for appointed fee-paid professionals who provide evidence to the court on behaviors of abuse victims and perpetrators, specify requirements for the contents of such professional reports, and require courts to find that any appointed professionals meet those standards. States should consider models under which court-appointed professionals are paid directly by the courts, rather than current practice, which is the parents are actually paying. Usually it's only one parent paying for the report, so you can see why they end up going south. And then the final point was that Congress will schedule hearings on family courts practices with regard to children's safety and civil rights. So that is now passed the U.S. House. We'll be working with the U.S. Senate in the next month to see if we can get both chambers on the record on that important piece of legislation. I also just wanted to bring to this board's attention that NBC Bay Area, which I mentioned to you at your Los Angeles meeting, was looking into these reunification programs that are essentially threat therapy, similar to gay conversion therapy, where youth are being threatened and essentially brainwashed to believe that they weren't abused by a parent. That first story came out a couple of weeks ago, and it's specifically framed as a lack of oversight for these programs. And one of the programs that this board has received multiple complaints about was the focus of that. It's a 5-minute story, and they are working on another story on another reunification program. So this is an ongoing issue, and NBC Bay Area is delving into that, and this board should be aware of that. And then finally, just I know the Enforcement Committee, is my understanding, will be the body that deals with the child custody stakeholder survey and coming up with what will come of that. I know that that committee has only 2 members and doesn't meet in public or doesn't even have public notices about its meetings, and I just would hope that even if there are strategic reasons that committee doesn't want to meet publicly, that at least those meetings be noticed for the public so they know when or if that committee is meeting. So I know it gets mentioned at these meetings, but not everyone in the public watches the video. So I think in the interest of transparency, just even listing on your website that the Enforcement Committee is meeting would be a step in the right direction. Thank you.
Thank you very much, Ms. Russell. Is there any public items comment or on items not on the agenda? Seeing no further public comment on the agenda items, what we're going to do today is we're going to move the agenda along based on what the action items are. There are certain things the board needs to take action on today, so we're going to focus our efforts there. So there won't be as much reports in terms of like enforcement report, budget report, et cetera, et cetera. So the first item that we do need to take care of is approval of the board meeting minutes for August 16th and 17th of 2018. Those were brought to you as a hand carry. We also received them by email approximately 10 days ago, 2 weeks ago, somewhere in that vicinity. I know that I had provided some comments ahead of time, not substantive comments, just, and I think, Dr. Horn, you'd also provided some grammatical and non-substantive comments.
I have, and I haven't had a chance to read these updated ones, so I don't know if they were added or not, or how should we handle it. Oh, sorry, I'm sorry. Thanks. Yes, I had, and sounds like they've been added to.
Both grammatical and non-substantive ones were already added. So if you want to address anything substantive, you can go from there.
Okay.
Okay.
So do board members have comments they would like to make on the meeting minutes?
Move to adopt the minutes as amended with the technical and non-substantive.
Okay, we have a motion and a second. Any discussion? Hearing none. Ms. Burns, could you call the roll?
Akoy-Badu? Aye. Bernal? Kasuga?
Aye.
Erickson?
Aye.
Fu?
Aye.
Horn?
Aye.
Phillips?
Aye.
That passes.
Okay. The next, we're not going to do, my item numbers are actually off because I made all my markup on an old agenda. The next one we're going to do is consideration of the implementation of the enhanced EPPP.
So I'm going to recuse myself from this part of the meeting. I work for ASPPB, the organization that is creating the enhanced EPPP, so I'll be back later.
We'll come get you,
Okay.
or text you, or something.
Okay.
That's okay. It's all very dramatic. It's kind of a dramatic moment. It's not often that the board is quiet. Okay. Dr. Kasuga.
Sorry? Oh. So at the last board meeting in August, the board agreed to put off the approval or denial of accepting the enhanced EPPP 2 or EPPP, and the board agreed to communicate to the Association of State and Provincial Psychology Boards, otherwise known as ASPBB, the concerns that the board had. We received the day of the board meeting communication about the enhanced EPPP, and it was unclear whether the exam was going to be optional or mandatory. As the hand carry item that you all have or should have in front of you, the ASPBB answered the two questions about cost and whether it was an optional exam or a mandatory implementation. And I'll just give the cliff notes that ASPB said they expect that there will be ongoing dialogue with member jurisdictions on this matter, and that formal decision on requiring the Part 2 will be made in 2022. They also laid out the tiered pricing for the EPPP2 to address the board's concerns about the cost of the examination. Included in your memo on this item is a recommendation from staff, and I can just go through the bullets. Board staff recommends drafting a letter to ASPBB based on the following. The Board of Psychology supports a competency-based examination, but feels that certainty is required as to its mandatory implementation on a date certain for all member jurisdictions. ASPBB would aid its member jurisdictions if it were to identify all statutory and regulatory changes needed to implement the new examination. This means drafting and supporting statutory and regulatory changes through advocacy, etc., over a set period of time, calibrated to the expected implementation date and the time necessary to effect needed changes. ASPBB should continue to evaluate the total cost of both examinations and establish a uniform lower cost to all jurisdictions as of the mandatory effective date of the enhanced EPPP. So that is the staff recommendation. As an aside, at the last board meeting, the board agreed to go through with option 3, which was the recommendation from the EPPP2 task force. This allowed for early eligibility to take the EPPP and then to, sorry, I'm blanking.
So early eligibility for Part 1.
Yes.
And then a later eligibility for Part 2
Two.
of the enhanced EPPP.
Right.
And for any of you members of the public that don't know, I'm trying to think of what the initials stand for, the Examination for Professional Practice in Psychology, or, yeah. It's the national licensing exam, to be similar to the national bar exam, that there's a national part to the bar exam. We also have another test that relates to law and ethics for the state of California. So, continue.
Oh, that concludes the report. Oh, just another quick refinement. Option 3 was a statutory change, which was some cleanup examination language that we had in the statute. That really doesn't matter whether the board goes up or down for EPPP. It's just cleanup language. And that was taken out of pathways and put to the board for consideration. The board agreed with that language. The regulatory language specifies about the part 2 of the exam, that it's offered through ASPBB, and then about the early eligibility. So that's kind of a recap of where we were in August. Staff recommendation is to ask for additional clarification on mandatory implementation date, and the rest is on the floor for board discussion.
So right now, we're in a wait-and-see situation. But before moving on, I just wanted to give a shout-out to Mr. Fu for taking over the reporting of the EPPP task force. And you did a great job. And thank you for doing that on my absence. And I think that the stakeholders' opinions from the EPPP task force have been brought to the attention of the board and will be taken into consideration in making, any decision in terms of adopting EPPP2 in the future. Yeah.
The awkwardness of this EPPP process has kind of been compounded, I think, in some ways by the uncertainty that's been created as to the implementation date of the examination. So we're trying to get clarity as to whether they really intend to make it mandatory or not. If they're not going to announce their intention to make it mandatory now, then it's very difficult for us to create a regulatory package to prepare us for implementing the EPPP if we don't know it's ever going to become the mandatory examination. So in some ways, they've put us in an awkward situation, and I think it'd be better to get clarity at this point than it would be necessary to rush ahead with any regulations or to formally consider adopting the enhanced EPPP or not. The problem we have, and I just want to highlight it one more time, is there has been a lot of concern and opposition expressed to the EPPP, the enhanced EPPP. We understand those concerns, and to a certain extent, we've tried to take those into account and create those as part of our advocacy with the ASPPB. However, to have a standalone licensing examination or a licensing examination that's not accepted in other jurisdictions is not really going to be a palatable outcome for our licensees, even though they may think at the moment that they would prefer not to have that, because it will virtually get rid of the ability to have a license that is in some way mobile or portable. In other words, if every other state's giving the enhanced EPPP and we decide not to, then we end up in a peculiar situation where our licensees can't go, like other licensees can go, to another state and say, I've already passed the EPPP, what more do I need to get a license in your state? You'd have to go through the process of taking a national licensing examination again, which I don't think is a very effective way of doing things. And similarly, because in the past, this state has been anomalous in certain respects as it relates to the practice of psychology and who could be licensed, we've worked long and hard to get to the position where people respect the value of our license in other jurisdictions. And I think we've definitely achieved that. I think we're widely respected. We are kind of the behemoth of psychology licensing. But that being said, I don't want to do anything that takes us backwards personally in terms of our ability to say psychologists in California are as qualified or more qualified than psychologists in any other place in the United States or the provinces of Canada. So that's my thought on the subject.
And we also don't want to act prematurely if there's uncertainty to what's going to happen in terms of making the EPPP2 mandatory and when.
So one scenario might be that they're going to say, we're going to kind of beta test it with early adopting jurisdictions, which is what they'd suggested, and that we'll make a decision at some point thereafter as to whether we're going to adopt the test or not. If that's the case, the board at that point could re-examine the EPPP, the enhanced EPPP, and make a determination of whether they want to adopt it at that point or not. But they're going to have to give us enough lead time in order for us to pass the necessary regulations and statutes, which I would say at minimum is 2 to 3 years. Is that fair? Yeah. So to the extent people are concerned about the enhanced EPPP sweeping into California and overtaking people's licensing, I don't think there's any likelihood if EPPP or ASPPB stays in the same posture they are, I don't think there's any likelihood that that's going to happen anytime in the near future. It may not ever happen. So who knows? It's all very uncertain. So I like the idea of getting some certainty.
I do have a question with regard to the outline for early adoption that they've provided, which is, and it's really a clarifying question more than that, is if we have a person who is attempting to get a license both here in California and perhaps one of the early adopter states, how will their Part 2 results be considered within California? Because that's during this interim period. So would it be that they would just submit the score for the EPPP Part 1 just for us? Excellent. Okay, that's helpful. So for nodding heads meant that, yes, we'll just take the EPPP Part 1 and we won't take the 2 result, but they can take the 2 ahead of time if they're qualifying for another state.
And take the complete.
And yes, and of course the complete as well.
This is a very good example, I think, of the myriad of problems that are created by having some states adopt early, some states wait and see what happens. It just doesn't strike me as being a very practical solution to the problem.
And I think for clarification as well, the tiered structure that they've proposed, or not proposed, but they are putting forth at ASPPB might give a false impression that if you take the exam under the reduced rate, it may protect you from any changes here in California. And I think from our perspective, it would be a prospective, if we were to adopt the EPPP Part 2, it would be from that point onward, not requiring anybody during this interim period to take the EPPP Part 2. So there would be no advantage, I would say, from our perspective of folks taking it just to take the reduction in the examination costs.
And there is something else about that structure where they're offering the EPPP Part 2 of the enhanced EPPP. The terminology gets very confusing. So the second part of the test, the skills-based part of the test, and they're offering a lower rate to states that are early adopters. And as the National Association of State and Provincial Psychology Boards, I do take some umbrage at incentivizing early adoption. It seems to me it's kind of coercive and probably not really appropriate to an organization we're a member of. The organization is trying to incentivize us into doing something at a regulatory level that really is our province to decide or not decide.
Question, how is it that those states are able to get early adoption so quickly if it takes 2 to 3 years for us?
Well, they
guess I know
may
the
not go
answer.
through as much regulatory review as we do. We're really careful about our regulations. And they may have state legislatures that can move more quickly because they might not have quite a complicated legislative agenda as we have in California. This is like a small country in its own respect. I mean, the number of people and the size of the budgets and everything. So I think it's a much more complex thing here. Correct me if I'm wrong.
No, I would agree. In fact, when I went to ASPBB, I heard some comments about rulemaking packages or regulatory packages taking 30 days. And I was very envious. But at the same time, I think it is good to have some level of checks and balances and having attorneys and staff and, boards look at language and how does it impact, and looking at all the different facets of rulemaking, so.
Another thing you realize going to an ASPPB conference, which I went to in a private capacity, was that there are states that, as it may have 250, 500 licensees, their board staff is like a person that's a part-time board staff member that covers like 2 or 3 boards. So a lot of them don't have the resources to analyze things in the way that we do, nor do they have as well-informed, I think, a licensed population sometimes. So they will almost, and I don't mean to disparage them, it makes sense in the situation they're in, they will almost automatically adopt virtually anything ASPPB puts forward because they don't have the mechanism for creating policy like that. Whereas we obviously have a big policy mechanism and are able to deliberate more carefully about it, for good or for bad. Yeah.
One question or comment really is for the staff recommendation with regard to the letter. One thing I would like us to consider is also requesting in that letter some sort of signaling with regard to a timeline. So I know we're asking for a date certain for members' jurisdictions, but also building into that date certain a lead up to that. So we're not finding out on that date certain it's mandatory. So some sort of lead time for us just to clarify with ASPPB.
Well, I think the idea was the date certain was announce a date you're going to do the test, and then we can decide whether we're adopting the test or not. Don't leave us kind of out in limbo and expect us to make policy in the absence of not knowing whether something's going to happen or not. Because I can tell you that the regulatory folks are not going to feel it's justified for us to pass a package that doesn't relate to a test that's not yet in existence. Might go through the process a lot faster and come.
And then the second consideration I would like to put forth is asking them when they would make that data available from their beta testing and from early adopters for the benefit of our Office of Examination Services. Because I think that was part of the discussion during the EPPP task force was part of our responsibility in terms of developing a competency-based exam is to evaluate the results. And to the extent which we have the benefit of early adopter states in other jurisdictions who are willing to go through the process, in theory that data should be available for our own Office of Examination Services to take a look. So I would put that forth out there consideration for this discussion here.
I mean, given the variety of different regulatory expediency in different boards, are we in constant communication with them that ours take longer and that we really do need the lead time in order for us to make any changes within our own
They're aware of that now. Yeah. We've made Mr. Fu and Ms. Sorek and I met with the ASPP Board of Directors in San Francisco when they were there after the APA convention. And we've impressed on them several times at this point that it's a long delay period. And they were happy to recognize that fact and were very cooperative with regard to it. So they know that there's going to be a lag time, which we were trying to build into the system when they were saying it was for a date certain. But then they kind of move back from that, so.
Gotcha.
I raised the data point because I know one of the concerns during the discussion from the EPPP task force were folks who did question the need. I mean, it's summarized in our memorandum, right? On, I think, point 1 or point 2. And I think just with the benefit of having early adopters make that with the data available, I think it might provide assurance for those who had concerns during the task force discussions that with those results, it might be the case that it is a proven necessity for additional examination and may move us in a different direction upon review of those results. So I put that out there as something we add to the letter.
I guess the question I have in my mind is this the point we asked for them to provide data, or do we try to see if they're going to just do a date certain and not do early adoption states? They wouldn't necessarily have to do early adoption if they made it a mandatory date. But I think it's an important point that we get that data, obviously, and I don't think OES would ever say that they would approve the test or allow us to use the test without having gotten it. So I think we'll probably get it somewhere along the way, and I do think it's an important thing to make a note of. But I don't know if it needs to go in, do you think it needs to go in this letter?
I think for me, I think it would reflect the commitment, the concerns of the stakeholders during the EPPP task force, and I think having it enumerated in printed form, and just frankly see what the response is. And also, I don't have the numbers offhand, but it seems like there are a number of states who are going to be early adopters. Is that correct? The smaller jurisdictions, is that correct?
Well, my impression was there were a number of states that indicated, and I don't even know how they'd make this commitment without having talked to their legislature, but that's a whole other question. But, and maybe they're structured differently and they have more latitude in terms of what they do. But there were a number of states purportedly that said that they were planning on adopting it. I don't think they were planning on being early adopters, they were just planning on adopting it. And then this whole idea of early adopters came up. But I assume that those states would probably continue to do that. I got the impression it was like 10 or 12 states that were ready to just go with it. There are other states, such as New York and Louisiana, that are vociferous in their hatred for the enhanced EPPP. I don't know that they've taken, I don't know that it's been a productive discussion that's going on there, but I think it may be part of the reason we're looking at the uncertainty that is now what their schedule is. Would you like to propose a motion adding in?
Sure. I would propose to adopt staff's recommendation with the amendment that we do include a request or some language with relation to making the data available for the evaluation of the exam by our Office of Examination Services.
Based on the
early adoption results.
Okay.
I second.
Do we have any discussion on the motion? Don't worry, we're now going to go to public comment. So is there any public comment? Ma'am? Yes, you do. And you turn the microphone on, you just push the button.
Oh, I don't have to keep it there the whole time. Okay. I'm Dr. Janet Farrell. I've been a licensed practicing psychologist in San Diego for the past 32 years. I'm speaking before you today to question the external validity or outcome data of the proposed EPPP2. The ASPPB has psychometric information available on the reliability. Can you hear me?
And I did want to say, in fairness to, if you can keep your comments 5 minutes or less.
Oh, definitely.
Okay.
The ASPPB has psychometric information available on the reliability and internal validity of the proposed exam, but I couldn't find information on its external validity or outcome data. By that I mean measures of competency in actual clinical practice that should be correlated with performance on what is supposed to be a competency exam. I wrote to the ASPPB and to their lead psychometrist about whether they had this data or had done any pilot studies on this, but I did not get a reply. I received my California license when the oral exam in psychology was still in place. It consisted of reading a clinical vignette, after which the examinee was required to correctly address 17 clinical issues in that vignette in order to pass. It is my understanding that the old California oral exam was roughly equivalent to the computer-based vignettes in the proposed EPPP2. One readily available source of data regarding the validity of the EPPP2 might be the effect of the removal of that California oral exam requirement on the performance of early licensed psychologists before and after the oral exam was dropped. That would be one piece of data that might prove or disprove the validity of the claim that passage of the EPPP2 improves the clinical performance of licensed psychologists. The slight financial advantages of California becoming an early adopter of the EPPP2 are, in my opinion, outweighed by the prospect of adding another test that has not been proven to measure clinical competency at all. Before this board votes to adopt the EPPP2, why not compare the complaint data on California psychologists who were and were not required to take that old oral examination? And if that oral exam data is considered too outdated or not comparable enough to the current EPPP2, then I suggest that the California BOP wait and look at the data from other states who do choose to become early adopters, like you were mentioning. But to me, the data is the key. What is that data? Their data is internal validity and reliability only, which I disagree with. What I think we should look at is complaint levels, especially regarding standard of care that come in against those who are and are not required to take the EPPP2. If the EPPP2 is in fact a valid test of competency, then the complaint levels should be significantly lower for those states that adopted the EPPP2 versus those who did not adopt it, particularly in the area of standard of care. After I passed the California oral licensing exam back in the 80s, for a time I coached other prospective psychologists in how to pass that exam, all of whom had failed the orals at least one time. What I discovered was that the people I coached were by and large knowledgeable and well-trained clinicians. They had failed only because they didn't know how to approach and prepare for the exam. Once I taught them how to do so, they passed. Does that mean that before I coached them, they were not clinically competent, and that after I coached them, they suddenly were? No. To me, it just meant that the exam did not, in fact, test their clinical competency. In closing, let's not rush to adopt the EPPP2, but rather let's look at the data to determine whether this test is a valid measure of clinical competency. In the end, I suspect that the best way we can ensure clinical competency in psychology is to rigorously regulate our training programs and to rigorously regulate our profession. And I think with the help of the California BOP, we're already doing a good job of that.
Thank you very much.
Good morning. I'm Cindy Yee Bradbury. I was a member of the task force, but today I'm here in my capacity as the director of the clinical psychology training program at UCLA. And I've also been asked to represent my colleagues at UC Berkeley and also the joint program here in San Diego. Our understanding is that there are multiple efforts underway to work with ASPPB to address the many concerns associated with the EPPP2, given that these concerns cut across stakeholders at virtually every level. And as UC faculty, we've been working with other educators nationwide, primarily through CUDCUP, which is the national organization that represents university directors of clinical psychology programs and includes about 174 members. We've been working with them to discuss our concerns with ASPPB and to offer potential solutions. So just to give you one possibility as an example, it might involve cross-tapering the current EPPP, so what would become version 1, with the new EPPP 2, and basically coming up with a single replacement that could be phased in. So this type of option would avoid placing an unnecessary time and financial burden on trainees, and it would also facilitate bringing much-needed clinical services to the public. So working together with a number of training clinics that includes counseling psychology, school psychology, training clinics, department chairs in psychology departments, CUDCUP is recommending to ASPPB that they slow down, that they alter exam development, and that they partner with stakeholders to address the many concerns around the EPPP2. And I have to say that we're encouraged that ASPPB has has already been noted, has rescinded the January 2020 mandatory adoption date, and also that, although I think you have a slightly different take on it, that states such as New York and Louisiana have basically made it clear that they're not prepared to adopt the EPPP2 in its current versions. So in light of these ongoing activities, it would seem that endorsing adoption of the EPPP2 in California would be premature at this time. And instead, we hope that the board might advocate on our behalf in terms of potentially, for instance, moving towards a single exam instead of following this idea that there would be a separate EPPP1 and a separate EPPP2. Thank you.
Thank you very much. Dr. Winkelman?
Hi, I'm Dr. Elizabeth Winkelman with the California Psychological Association. Our organization, our board of directors, in response to many of the stakeholder concerns that have been already discussed today, came up with an official statement, and if it's all right with you, I'm going to, it's brief, I'll read it into the record, and I have some copies for distribution if that's permitted later, or if people would like to pick one up later. So the California Psychological Association appreciates the excellent work of the Board of Psychology's examination for professional practice for the EPPP Part 2 task force, and agrees with their summary recommendations, quoting from their recommendations, that the task force does not believe the EPPP Part 2 is in the best interest of California consumers for the following reasons: lack of a proven necessity for the additional examination, considerable concerns related to the examination design's ability to assess skills and thus potentially providing negligible consumer protections, the additional examination's additional costs and burdens on prospective licensees, and especially on historically underrepresented and socioeconomically disadvantaged students, and the additional examination's creation of new barriers to licensure and potentially detrimental impact on access to psychological services to California consumers. Subsequent to, as we've been discussing, now I'll get back to the official statement, subsequent to completion of the work of the EPPP2 task force, and in response to stakeholder concerns from throughout the United States, the ASPPB rescinded its requirement that the EPPP2 be included as a mandatory component of the EPPP starting in January 2020. The EPPP2 will instead, and this is quoting the ASPPB letter, will be optional starting in 2020, and ASPPB has stated that after several years of experience of jurisdictions using the EPPP2, they will evaluate that experience and decide on future directions for the national licensing exam. So, consistent with the EPPP2 task force recommendations, CPA opposes California becoming an early adopter of the EPPP2. Furthermore, given ASPPB's current position, CPA recommends that the board closely monitor future developments, including emerging data regarding the EPPP2. Specifically, we ask the board to request from ASPPB data to substantiate the need for the EPPP2, as well as evidence of its effectiveness in reliably assessing relevant skills and competence. These data could be used in considering the costs and benefits of potentially adopting EPPP2 in the future. Thank you.
Thank you. Any further public comment? I do want to just acknowledge that I think that the concerns you're raising are important ones. And I don't think we're in any danger of being an early adopter in this moment, unless there's sentiment on the board that I'm not aware of. So I think that we just need more information.
Question, clarification. The data that we're hoping to get from early adopters, will it address at all the external validity that was raised, which I think is a very important point? Do we know?
Well, the letter has not been drafted yet, but we can certainly include external validity as one of the forms of data that we're looking for.
I mean, that seems to be one of the very central issues in this whole process of assessing competence. Is there validity with clinical practice?
And that was, I think that was part of what sunk the original oral examination, that they didn't have a data set to back up that it was really a valid measure of whether people were competent or not. It was also because it was not reliable across. There was no uniform protocol that they used. So, and you'd have just 3 random people sitting in a room. So I think that things like the enhanced EPPP Part 2 are an attempt to address that and move away from just simply having a knowledge-based test. But there are serious questions that have been raised about the data that would support implementing this test, and I think we can include that in the letter. You need to come forward.
Oh, I'm sorry. I have concerns about why external validity was not addressed in the first place. I was a NIMH research fellow, and we spent so much time on external validity of our studies. To me, the internal validity is relevant if you don't have external validity, and yet I can't see that the ASPPB has been at all concerned about that, and that's baffling to me, and it troubles me in going forward and making recommendations to them, thinking that they would operate with this mindset.
Well, I think what we can say at this point is we want to express curiosity as to what data they're basing the examination on. I can't respond. I don't know what ASPPB's response would be to that. So
well,
it's a good question.
In their literature, what I saw in response to those kind of questions weren't exactly those kind of questions, was more about whether or not the particular item was replicable, which is irrelevant. That sort of thing. They didn't seem to get what we were even asking for. So that was my concern.
Thank you.
And I think just for the benefit of tying it back to the comments we heard, that the board letter today is not an indication at all of early adoption, nor is it a suggestion that we are adopting the EPPP2 task force. I think this continues our fact-finding mission that we've been on since June or April of this year. And so the board letter today should be seen as you just said, Dr. Phillips, our curiosity and continued discussion. That being said, I'm intrigued by what Dr. E. Bradbury said about the effort to have some consideration at the end of the day for a single exam. And I would be curious, again, as a point of discussion for the board, is if we could add to this letter, and I know it's becoming a Christmas wish list, but this idea of just asking them what is their response to CUDCUP's suggestion to them. And it's just a question.
I would prefer not to do that, and with all due respect to Dr. Bradbury, simply because then we're now aligning ourselves, and we need to think of the North Carolina dental examiner's case with professional advocacy groups that are representing the profession more than they're representing the regulatory environment. So I don't know that it would be appropriate for that, but I would certainly hope that CUDCUP's going to get an answer, and that the answer will be shared with us, so that we have all the information that we can work on.
Yeah. That's helpful, Dr. Phillips. And then the other question I have is just if we can get an update. I know with the option 3 that we went forward with in August, if we can have an update maybe sometime next year on which milestones we've hit, so that we can sort of parallel what we're hearing from ASPPB in a meaningful way. Or if there's no need for that, that's fine too. Do we need?
What milestones are you talking about?
Maybe this will address the statutory changes that were part of option 3. The board can proceed with that because it irregardless of the enhanced EPPP, that's cleanup language for our exams. But with the regulatory language, staff would wait until the board would have an affirmative answer on the enhanced EPPP before proceeding on a reg package. So I don't know if that helps.
That answers the question perfect. I remember the discussion. It's all blurring together, frankly, all these discussions. But I remember the discussion in August about how there might be a necessity at some point for us to consider pulling back the package, but it sounds like we've now benchmarked it to just the adoption period. So that's helpful.
The package is not a package. It's a draft document somewhere in the computer somewhere. But just to make it clear, the legislative change that we've decided to move ahead on is simply clean up language that allows us flexibility relative to whatever test we're using. So it's nothing to be concerned about. We're not slipping something through the back door.
And of course, anyone can go on our website to view those materials that were adopted by the board, so you can always look at old board meetings to see that statutory language.
Elizabeth Winkelman again from CPA. I just wanted to make a very brief follow-up comment to Dr. Farrell's, which is that we are also concerned about external validity, and that would request that the board would consider specifically asking for that data in the letter when we're asking for data. Okay, great, thanks.
I am happy to withdraw the original motion and put in place a new motion that includes that piece of external validity as well.
I second. I seconded.
I'll be glad to offer a second to that motion.
So why don't we go ahead and call the roll?
Okoye-Bedeau? Yes. Kasuga?
Aye.
Erickson?
Aye.
Fu?
Aye.
Horn? I'm sorry. Phillips?
Aye.
Okay. Passes. You got it.
Dr. Phillips? I just wanted to comment that I think our public comment on the last topic was particularly useful and helpful, and I'm appreciative to those that provided input to the board.
I would agree. Let's move on to actually an item that was in the earlier agenda, but we put off, relating to the Department of Consumer Affairs update. We have the honor today of having Ms. Karen Nelson with us. She's the Assistant Deputy Director of the Division of Board and Bureau Relations, and she's always very patient with me. I always mean to move her up earlier in the proceeding, but never quite do it.
No worries. Thank you, Dr. Phillips, President Phillips. Good morning, board members, EO Sorick, Executive Officer Sorick. Thank you again for allowing us an opportunity to provide a brief update with regard to recent activities with the department. It's always fantastic to be with you all, so I always look forward to having your quarterly meetings. So here we go. So few updates. First, with the Director's Quarterly Meeting on October 29th, the Director hosted the last 2018 Director's Quarterly Meeting in Sacramento. At this meeting, DCA provided an update on the Division of Investigations Client Survey, the Executive Officer's Salary Study, and shared a draft plan to assist our boards and bureaus with implementation of AB 2138 by July 2020. DCA's Public Affairs also previewed the new video, which provides an overview of DCA and the 37 boards and bureaus it regulates. We're currently working on scheduling the 2019 dates, and we will provide those to the board as soon as they're available. Second was specific to the licensing and enforcement work groups. Those groups do continue to meet monthly. And again, we want to thank the board and their staff, specifically Stephanie Chung and Sandra Monterrubio, for their active participation. They've been very vocal in the dialogue, and those have been very helpful. So we do hope they continue to attend those meetings and engage in the dialogue. In October and November, the OIS data governance team previewed an interactive reporting tool to promote openness and transparency in the reporting of performance metrics, such as the annual reports data and the quarterly enforcement performance measures. The tool is designed to be interactive and intuitive and allows users to create custom analysis and visualizations. So if you imagine in your packets you have your charts and such, this tool will enable them to click and customize things that you are then able to look at, see trends and all kinds of various things. Third, specific to the Future Leadership Development Program, the department kicked off the meeting with a second cohort in September. And as you may remember, the Future Leadership Development Program includes executive mentoring, customized leadership training, and project management. This year, 7 individuals were selected to participate in the cohort, and the cohort was broken up into 3 teams and will be taking on 3 different projects. The first will be looking at subject matter expert witness program, and this team will research best practices as it relates to the use of expert witnesses, including evaluating costs, training, the expert pool, and the usage of the program. The second team will look at the performance measures with enforcement, and they will examine the current performance metrics while also introducing and proposing an adoption of potentially 2 metrics specifically around tracking pending cases. And the third team will look at an awareness campaign for California veterans and spouses, and they are proposing the creation of a DCA committee that is tasked with community outreach to inform and educate Californians of the benefits, resources, and opportunities available through DCA. Next, with the Substance Abuse Coordination Committee. On October 30th, the Substance Abuse Coordination Committee met to continue the discussion about Uniform Standard Number 4 that addresses the drug testing standards for licensees who are on probation or a diversion program. And at the meeting, the committee voted to make 2 changes. The first gives boards additional flexibility for testing licensees who are going on vacation or must go out of state or out of the country. And the second change allows boards to lower the drug testing frequency if a licensee receives at least 50% supervision in the workplace. And that concludes the update for the department. And as always, thank you for your service and your work, and let us know how we can be of service to you.
Do any of the board members have questions? I had a couple quick questions that you may or may not be able to respond to.
Okay.
One was the status of the pay study that was being done about executive officer salaries.
Mm-hmm.
And the second one is, there had been a meeting, which I thought was going to be quarterly, but maybe I misunderstood, of the presidents and vice presidents of the board with the directors and key players in DCA. I don't know if that's a process that's going to continue.
Yes, so the first question with regard to the salary study, a contract has been, is underway, actually. It's with an independent consultant called KH Consulting, and that project is going on at the moment and will be completed about spring 2019. So I'm happy to come back to the board and provide an update on that when that is available. And with regard to the leadership call, we are looking at a date in December. So we're hopeful to send that to you very shortly. I know it's kind of around the corner, so we'll be sure to send that over to you as soon as we get it confirmed.
Well, thank you very much.
Thank you.
Any questions from the public? Well, thank you very much for making the trip down to share that information with us, and it's always a pleasure to have you here. We're going to, just so people know that are still checked in, that we will be breaking at 11:50 for purposes of people being able to check out in a timely fashion, since, as I understand it, there is a 12 o'clock as a 12 o'clock final checkout time. I'm just trying to figure out where we want to go. Do we want to go to? Yeah. Yeah, let's start on the enforcement report. So, Ms. Akwebadu, we're going to jump ahead to the enforcement report. Antoinette, Lucille's trying to get your attention.
The Enforcement Committee report, and I will be talking about the child custody stakeholders. Or do you want to say anything first, Antoinette?
Let me get down to that
Okay.
item, sorry. Okay, so included in the meeting packet is the Enforcement Committee report. And it's broken up into different parts and pieces. The enforcement, I'm sorry. The Enforcement Committee attended the Child Custody Stakeholder meeting on September 21st, 2018. And Ms. Akwebadu, did you want to just briefly?
Yes, I'll briefly just share
Sure.
with them about the meeting on September the 21st. The stakeholders who were invited participated in the meeting to discuss the concerns from the Center for Judicial Excellence, and in attendance were, of course, the Board of Psychology and Behavioral staff, the DC Executive Office, the DCA Legal Affairs, the Judicial Council of Family Law, the Senate Judiciary Committee, the Assembly Business and Professions Committee, and the Office of the Attorney General, and the Center for Judicial Excellence. And attached is a summary of the stakeholder meeting and the survey results. And the Enforcement Committee will meet with enforcement staff at the next Enforcement Committee meeting to discuss the concerns of the Center for Judicial Excellence. And there will be a meeting coming up in February as well regarding that. So, did you have anything else you wanted to add to that?
So the intention, as I understand it, Madam Chair, is that we're going to discuss those things in the Enforcement Committee,
Yes.
try to come back with some specific action
Action
items,
items.
and bring those back to the board to discuss in a public forum where there'll be an opportunity for public comment. Because of the vagaries, as you recognize, Ms. Russell, because of the vagaries of what we do in Enforcement Committee and the confidentiality of ongoing enforcement
Yes.
cases, it's not appropriate for us to have that as an open meeting, but we will be meeting, I think the next meeting is in February, correct?
It is.
The next meeting will be in February. We will be discussing it, and we will be bringing it back to the next quarterly board meeting. So we want to move quickly on this, but there is February board meeting, correct? Thank you for clarifying that. We are concerned of moving this quickly, but it's the very nature of the organization that it takes some time for the committees to meet and then make recommendations to the board, but we will make that a top priority.
And there was a survey that came out of that as well, which I think is attached in the minutes, in the meeting report. So thank you, Dr. Phillips, for that. And thank you very much for sharing why our meetings are not just open like that, because they're highlighted. So, yes, and we will move on to the voluntary surrender of license as well. And so in October, did you want to say anything before that, or do we want the public to, each one at a time? So do we have any public comment on the first one, which was the child custody stakeholder meeting? And we will do it one at a time as we go through it. Thank you. Yes.
Thank you. Yes, thank you, Kathleen Russell, Center for Judicial Excellence again. I just want to clarify that you were saying there's a meeting in February. That is the quarterly board meeting, but you are also saying that the Enforcement Committee meeting is meeting in February as well?
We'll be meeting, if I'm
before.
correct, it's prior to.
Yes, before.
Prior to the board
our
meeting, right.
Board meeting.
Okay, so there will be an agenda item at the February quarterly meeting about the Enforcement Committee's
Yes.
recommendations coming out of this
It will, yes.
child custody. Okay, and then the other question I have is, in reviewing the summary report that came out of the stakeholder meeting, there were comments in the margins by participants as they were ranking the different recommendations that the Center for Judicial Excellence made. And so what would be the proper venue or mechanism for the Center for Judicial Excellence to feedback on some of those questions so that the Enforcement Committee has complete information, I guess?
Ms. Russell, if you could submit any perhaps written comments on the summary, and that can be provided as a document to the Enforcement Committee when they are considering the summary report and any follow-up recommendations to make to the board meeting in February, that would be really helpful.
Okay, and who should I submit that to and by when?
If you could submit that to Sandra or myself,
Okay.
and if you could, the soonest you can do that, the more time that the committee members will have to review that information. But I would suggest that if, I believe it's the first week of February, the committee's meeting, so I would say at the latest 2 weeks prior
Okay.
to that would be great.
Okay, great. Thanks so much.
Any other public comment? Hearing none, we will move on to any other comment. Yes.
Just so you'll know,
Yes.
Madam Chair, we do want to stop in another approximately 10 minutes, so perhaps we can start the discussion of voluntary surrender of the license, and then we'll complete the discussion after lunch.
You want to, or just stop now?
Well, given how packed the agenda is, we might as
You
well
wanna
start
get
now.
as much as
Yeah.
as possible. Very well. So we will move on to the voluntary surrender of license. And in October, the executive officer, the enforcement staff, and the DCA legal counsel met to discuss a possible mechanism for licensees with a cognitive impairment or incapacity, and without a pending complaint involving client harm, to request the board's consent to voluntarily surrender a license without formal discipline. And the following is a preliminary outline of this proposed policy. And it was 9 items that that were moved forward, put forward. The one is the complaint is opened, the request formal investigation, the investigator and the board expert to review licensee, the family, co-workers, and witnesses, and the board expert determines whether or not licensee understands the decision they would be making by voluntarily surrendering their license. And 3, the final investigative report is submitted to the board staff for review, and 4, the board staff sends licensee a letter offering voluntary surrender, and 5, the licensee has 30 days to submit written request for surrender containing the licensee's signature. The scanned letters are acceptable. And 6, and they are on the board, thank you very much. They are on the board there, and the board issues, 6, the board issues letter to licensee acknowledging and consenting to the surrender with an explanation of petition for reinstatement process, and and the others are 6, 7, 8, and 9, and you may read at your pleasure as you choose. And those are the preliminary outlines for this proposal of surrender policy. So I will give you time to read that, and then perhaps we will be able to finish. and then a couple of minutes, and then we will ask for public comment and discussion.
Two other items that are included after the policy, as Ms. Akwebudu just laid out, are the draft letters to implement the process, as well as proposed statutory language. And the proposed statutory language would be for those that would want to reinstate after voluntarily surrendering their license.
Okay. And that's there.
So I have a question.
Yes. Has everyone had an opportunity, I know, Jay, but I'm asking, has everyone had an opportunity to kind of read that and digest that? And then I will open it up for questions. Okay. Go ahead.
Okay, thanks. On the list of, on the memo from Sandra that talks about the background and the preliminary outline of the policy, number one is complaint is opened. But you've said that this is someone who hasn't harmed anyone. So what do you mean complaint is open? I guess that's what I'm asking.
So for any issue that comes before the board, and the typical scenario that we're envisioning is a colleague contacts the board, a family member lets us know that Dr. So-and-so is showing some cognitive issues, we have some concerns, and this starts the ball rolling. Anytime we get any complaint or any concerns related to the board, in the past we didn't necessarily open a complaint, but this is just how we quantify the time and the workload and going into our licensing and enforcement system. Once the complaint is opened, then we go through the process. Once the evaluation is made by the expert and the investigator, whether this person is a candidate for voluntary surrender, then they would stop, as we called it, you're on the freeway. Do you make the exit off with the voluntary surrender, or do you stay on the freeway and it becomes a complaint?
Right, then it becomes
and we want to make sure we're looking into the issue, and that's our current process now.
So, yeah, I'm just questioning the use of the word complaint.
A complaint doesn't require consumer harm.
Okay.
It could be anything that brings to the attention of enforcement something that needs to be investigated.
Right.
Yeah, so I think it's just their use of terminology.
It's just the use of, that's just what I wanted to clarify. It's like this doesn't go anywhere that there's been a complaint necessarily.
No, and complaints are never public. It's just the actual discipline that would be public if there were discipline imposed on a licensee or administrative.
The only part
but a complaint is never going to be public.
That's how we quantify it. That gives us a way to track it.
It puts us in the tracking process, and right.
Okay, thanks.
I'm sorry, did you say something? You sure? Okay. Any other questions or comments? Yes.
On page, the letter, the draft letter, on item number 2, it said that the board would consider the request to surrender, but it seems like from process standpoint that the meeting beforehand would have occurred already. So is that just a formality in terms of notifying that the request is received and that it's for further consideration and it's with the likelihood that it will be approved, or is that person subject to additional investigation for that determination of surrender?
It's because there's a possibility that somebody may make a complaint in the interim, so we wouldn't be able to accept a surrender if we had a consumer complaint of harm. I'm teacher's pet today.
No. That was asked in the meeting. Are there any other, thank you. Are there any other questions or comments from the board? Yes.
I think it's a great idea to do this, especially as the profession is aging, and I just think it's a good idea, so glad we're doing it.
And just from a comment point of view for myself, I think what we're trying to do is be non-punitive with people that are going through cognitive decline or whatever it is that's incapacitating them from continuing to practice psychology. Obviously, where there is consumer harm, we have to treat it in a very different way. But if it's just a question of someone losing capacity, we want to give them the opportunity to surrender their license so they don't actually have to go through formal disciplinary proceedings where we take away their license, which is a very different experience for people. That may be necessary in some of these situations, but we want to at least give them the option. There have been, at least I know of one advocate that thinks even if there has been some kind of consumer harm or complaint of consumer harm, you should still allow the surrender. That generally I think has been felt by staff and by the committee to be an abnegation of our responsibility to protect consumers and to take appropriate action under those circumstances. So that has not gone anywhere in our discussions.
So is this mostly for people that have a more permanent cognitive impairment, or does it also apply to someone who has like a temporary cognitive impairment of some sort?
Mostly cognitive impairment. That was the purpose.
I think what we're talking about is people who have a permanent cognitive impairment.
Yeah.
I mean, it might be necessary to investigate somebody that has a temporary cognitive impairment if it appears they're not capable of doing it. But I don't know that we'd necessarily need to ask them to surrender their license right away. It might be more appropriate in that circumstance for the person to stop practicing until they have had a restoration of their cognitive capacities.
Okay, thank you.
And what I would just also say is for those that have a temporary health or cognitive issue, they always do have, as a licensee, the opportunity to go inactive. So if you were experiencing health concerns that were making it so that you could not practice, you can always put your license to inactive instead of going in the surrender route. So for things that are temporary and for critical health issues, we get calls often, and that is always the option to go inactive.
As warned, we're going to have to put a pin in the discussion.
Yes, very well.
And so we'll come back after lunch and do that. I'm going to say it's 10 of 12. So many people need to check out. I would like to reconvene at 1 p.m.
Okay.
And we're going to march through as much of the agenda as we can get through. Thank you. We'll reconvene at 1.